Okay, so very good afternoon to everyone. Let us start a lecture on cyber securities and laws. So if you remember in the previous lecture, we were speaking about the electronic banking in India. And then we went towards understanding how because of electronic banking in India, today we have a lot of things available. So it was because of an electronic payment system, RTGS, NEFT, IMPS and everything made possible. We have also seen IDRBT, that was Institute for Development and Research in Banking Technology, which was established by RBI in 1996, and which has led to Infinite in NEFT. So if you remember, because of an Infinite, everything was made possible, like ECS and RTGS and NEFT. Then we also seen how NEFT, that is National Electronic Fund Transfer, is made possible, and then how with NPCI has introduced many innovative services such as Rupee, Beam app, UPI, IMPS. So all of this which we are actually using today. So let us again proceed further from where we left. So let me just start this screen share and then we can continue. Once again, I'll just remind those who are having the KT from SEM 1 to SEM 6 are requested to write their details and then they can join the meeting which is scheduled for them at 2 p.m. So I think the details are posted in your group. So you can check the group and accordingly join that meeting. For the others, you all can attend the lecture. So just notification for those who have it. So let us just continue. So let us start with the lecture. Okay, so let us start again our lecture on from where we left. So coming back to it, we are about to see what are the Indian laws. Let me just maximize my screen. Yeah. So again, when we speak about the Indian laws which is related to electronic banking, so it was the Indian IT Act which was amended, which amended the existing laws to incorporate and facilitate the electronic banking in India. So it was IT Act which actually amended the existing laws. That is, some of them were Bankers Book Evidence Act 1891, Reserve Bank of India 1934, and it was the Payment and Settlement System Act 2007. So each one of them we are going to see in detail, and we are going to try to understand all of them, right? So few new acts have been added to support the system of electronic banking, and following are the laws and the amendments that are made by them. So we are going to see the few acts with which we are going to understand the same. So we are going to see each one of them in detail. Bankers Book Evidence Act of 1891, Reserve Bank of India Act, RBI Act of 1934, and Payment and Settlement Systems Act of 2007. Right. So Bankers Book Evidence Act of 1891 was enacted to amend the law of evidence with respect to bankers book in 1891. So this law is actually applying to all the legal cases which involves financial transactions where the banking records can be cited as an evidence, right? So this act contains total of 8 sections which briefly states the provisions including definition, scope and objective of the act. So any institute or any company which carries out the operation of banking is bound by the act, and if any legal proceedings is initiated against them, then they are liable to produce all the banking records to them, maybe including the ledger, account books or any information related to record keeping if ordered by the court, if it has been asked to do so. So there we have a Bankers Book Evidence Act, right? So bank, based on that, the IT 2000 has made some amendment to the Bankers Books Evidence Act. Now, what is IT Act of 2000? We are going to see again in detail, probably in module number 5, when we are going to speak IT Act in much more detail about what is IT Act 2000 and what are the different laws it has and what are the punishment is being. So entire details about IT 2000 is a part of module number 5, which we are going to see once we do complete this module, right? So if you can see, that you have several amendments in the subsection which is 2.8 of the Bankers Book Evidence Act, which allows to make the printout of the data stored in bank computers or various storage devices such as floppy or disk, as a valid document and evidence. So if you can see here, if I see the subsection 2A, it says that it can consist of a printout of the data which can be stored in the floppy disk, tape, or any other electronic data storage. So such can be used as a valid document and evidence, right? So that was amended again and to allow the conditions for the printouts. Similarly, the printouts needs to be accompanied by the certificates that described in section 2A that you can see, which was added after amendment by the IT Act 2000. So the first certificate, as we see, is required, stating that it contains the extract from the official records of the bank. So if you can see, the banker's book includes the ledgers, the day books, the account books, and all other books which is used in the ordinary business of a bank were kept in a written form or printouts of the data which is stored in a floppy disk, tape, or any other electronic magnetic device. So this certificate is required, stating that it contains the extract from the official record of the bank, and such a certificate needs to be issued by the branch manager of the bank, right? And the second certificate requires must be issued by the person in charge of the computer system. So probably if you're taking evidence in the form of floppy disk, tape, on an electronic media, then it has to be issued by the person in charge of the computer system, typically the system administrator, stating that the computerized system from where the printouts are taken have proper measures implemented to ensure the integrity of the data, and it cannot be manipulated nor it can be accessed in any unauthorized manner, or it can never be tempered due to system failure or any other reasons, right? So this is what it's been stated that when we speak about the Bankers Book Evidence Act, so you see IT Act has made several amendments to the Bankers Book Evidence Act with subsection of 2.3 and subsection of 2.8, so that you can already see, and which speaks about the Bankers Book Evidence Act, right? So in the section 2A, there are the Bankers Book Evidence has given what can be the conditions for the printout, or what are the printout which is being said in subsection 8, what should it should consider. So they have said that it should consist of the certificate to the effect that printout of such printout should be from the branch manager that we have already discussed, a certificate by the person in charge of the computer system, which gives you a brief description of the computer system. There should be a safeguard adopted to prevent and detect any unauthorized changes to data. It means data should not be changed. Plus, there should be a safeguard to retrieve the data. Plus, there should be the mode of identification of such data storage device. So all the different points, if you can see, section 2A speaks about all the conditions of the printouts that is acceptable in the court of law, right? So you can see there are several points that has been discussed, and that you can see wherever you wanted to understand in much more detail. You can go and understand about Bankers Book Evidence Act in detail, which gives you all the detailed explanation of the same, right? Going further, let us now understand what is the RBI Act of 1934. So the RBI Act, that is the Reserve Bank of India Act of 1934, is actually the legislative act under which the RBI, that is the Reserve Bank of India, the Central Bank of India, was formed, and it started its operation in 1st April 1935. So Reserve Bank of India, the Central Bank of India, and they have formed this act, and they have started commencing the operations on 1st of April 1935. So what it does, it provides a framework for the supervision of the bank and any other related matters in India. So this is been done to actually supervise, or to make sure supervision of the banks and any other matters in India. So what it does, it empowers the Reserve Bank of India to act as the banker to the government and manage all the public debt. So it is being there to empower to act as a banker of the government. So as per the section 22, only RBI can issue and regulate the currency notes in India. Nobody else can issue and regulate the currency notes in India. It is only the RBI. It's only an RBI which needs to make sure that it is being allowed to do so, right? So the Reserve Bank of India Act 1934 was again amended by the IT Act 2000. Now we are going to see again IT 2000 in detail in later on. But then the RBI Act was again amended, which was again initially on 1934, which was amended by the IT Act in 2000, in which there were several additional of the clause in section 58 were made to ensure electronic fund transfer, and probably the admissibility of documents and records are taken into consideration, right? So it was again amended in IT Act 2000, where they have tried to ensure electronic fund transfer, that is EFT, and all the legal admissibility of the documents and records are being allowed. So this act actually deals with the regulation of funds transfer to 15 electronic means between the banks. So RBI Act 1934 again deals with the regulation of the fund transfer through 15 electronic means between the bank, which include RTGS, NEFT, IMPS, and all the other matters. Okay, so this is again one of the act that we have seen. The next one is the Payment and Settlement Act 2007. Now the Payment and Settlement Act, it is also called as PSS Act. So the PSS Act of 2007 was legislated in 2007 to govern and regulate all the mode of payment systems used in India. So it gives power to the RBI to direct and regulate the payment system and the payment system participants in India. So we know that nowadays there are several payment systems option available, right from credit cards, debit cards, smart cards. So there are different ways in which electronic fund transfer any operation takes place. So it is under PSS Act that is being done, right? So it does not include any payment operation which involves the stock exchange. So anything in which a payment is made to a stock exchange or clearing done under stock exchange is not covered. But apart from that, all the payment system which includes the payment operation like credit card, debit card, smart card falls under the Payment and Settlement System Act 2007. Right? So the section 21I, the section 21I of the PSS Act 2007 defines that the payment system enables payment to be effected between a payer and the beneficiary, which involves clearing, payment and settlement, but does not include a stock exchange. So that we already discussed. That PSS Act will allow you to make a payment between a payer and between the beneficiary, but then it will not involve any stock exchange data. Right? So these are the different types of an act which follows under the banking and that we have seen. Right? Since we have seen all three of them, right from, if you have seen, we have been to Bankers Book Evidence Act, then RBI Act, and then finally the PSS Act. Let us go ahead and now discuss about what is the need for the cyber law. Why there is a need of an Indian cyber law. Now, clear answer to this, you can see again in this slide, then what is the need of the Indian cyber law? So if we just go and try to understand what is an actually reason or why there is a need for the Indian cyber law, so we'll come to know the answer that over the years, the internet has grown beyond what it has been developed. That is research and sharing of information. So right over the years, internet has made a very huge contribution, right? So nowadays it is used for social networking, online transactions of the data and money. Everything is happening online where we make use of the internet, probably right from doing an e-business to e-commerce to e-governance to e-procurement. Everything is e. It means we are making use and we are making the use of internet at the end. So everything right from social networking, right to electronic transactions, right to electronic communication is happening on an Indian law. So that is the reason there is a need for an Indian cyber law. So if you can see, according to the iCube 2018, according to the iCube 2018 report, which is done after researching from a market research firm, Kantar IMRB, which was published in March 2019. So according to that report, it was said that that there is again an internet usage increase in the rural India. So number of internet users in the country is going to go high and high because again it is again an increase in the internet usage in rural India, and number of internet users in the country will reach 627 million by the end of 2019. So this was being done again a research in 2018 by Kantar IMRB, and on that report of iCube 2018 they have mentioned that there will be again a growth in the number of internet users. So because there is a growth in the internet users, there is a need for an Indian cyber law. So while internet users grew by 7% in urban India, reaching 315 million users in 2018, rural India registered a 35% growth. Just think, the urban India grow at a rate of 7% in urban India, while the rural India is growing at you can say a 35% growth in the internet user over the past years. And then it is again estimated that there are 251 million internet users in rural India. Just see the figure. There are total of 251 million internet users in rural India, and this is expected to reach almost 300 million. So obviously the number of users are keeping on increasing, and that is the reason it is always necessary to have some law. There is a need to have a law. What if some breach is done, or if somebody does an attack, then there should be some rules, or there should be some method for identifying, and a punishment should be given accordingly, depending on the crime that has been done. So there is a need for an Indian cyber law. So along with cybercrime, even conventional crime have some aspects of technology involved. For example, use of digital evidence in the form of mobile phones, using audio recording, video recording, maybe email, maybe the chats, which are can be used for an investigation. So there should be some law, or the conventional law that we have initially, they are not adequate to deal with such kind of the complex challenges by the use of the technology for communicating crimes, right? So far we have been following only conventional law, but then there are nowadays crime happening where the use of mobile phones, maybe the audio recording, video recording, or maybe even the digital communication is happening with the help of an email, or maybe through a chat. So current laws are not adequate to deal with the complex challenges posed by the use of the technology for committing crimes. And by 2021, if you can see my last point, it is saying that by 2021, it is estimated that there will be about 635.8 million internet users in India. So with such an increase in the number of users and the applications of the internet, there are 100% chances that there are going to be misuse. So the increase in the misuse is also going to happen. That if there are so many people who are going to make use of an internet, there are chances that there will be an increase in the misuse. Is also accepted, right? So yeah. Okay, another reminder once again, I just got just a reminder to everyone. Those who have a KT in SEM 1 to SEM 6 are requested to attend the meeting. Those who have it can leave the meeting and can attend that. Those who are leaving can just write their details in the chat box, UIN number, name, and roll number, and you can attend that meeting if you have a KT from SEM 1 to 6. Yeah. So coming back to speaking on again on Indian cyber law, we have seen that India is extremely detailed and well-defined legal system. But then again, India is very good in the legal system. But then most of the laws were enacted before the emergence of the digital era, and they are not designed keeping in mind the internet and computer systems. So these conventional law are not adequate to deal with the complex challenges which are posed by the use of the technology for committing crime. And this law could not be interpreted to include all the aspects which is related to different activities in the cyberspace. And then they could not give any legal validity, or they cannot give any legal sanction to such activities. And then yes, because of that, there is a need for Indian cyber law. Clear so far? If you can just write it. Have you understood? Okay, Saqib. Yeah. Thank you, Mohit. Yeah. So these are some of the reasons. Let us go to the other slide and let us see that what are some more few challenges why we lead the Indian cyber law. And then this is the last module, and then we are going to end with module number 4, right? And then we're going to start with module number 5. So the last topic again, with the last point we were speaking is on again an Indian cyber law. So there are some again more points why there is a need of Indian cyber law. You can see that there is an increase. We have seen that conventional laws are not adequate to deal with the complex challenges with the use of technology for combating crime. And today, the technology has become part of almost all the activities, right? I hope all of you agree. So some of these activities can be something like this. For example, almost all the business, almost all the individuals now make extensively use of the computers and computer networks for making various business processes. Maybe for doing, even if you can see, if you have seen the movie Scam 1992, Harshad Mehta's movie, the story that you might have seen, web series. If you have seen the initial time which they have shown how the stock market used to function, and just see now how the stock market is functioning. So you can see everything has come online. You might have seen that movie, the 1990s, how the stock market used to function and how difficult it was to deal with the shares of the stock markets. But if you can just see how now the stock markets are being done. you are still doing the same kind of buying and selling of shares, but the difference here is how easy and how convenient it is to buy and sell the shares online. So even online stock trading is being done online, right? Everything, whatever we think, right? We make use of the computer and computer networks for almost everything, right? From business and everything. So due to increase in such activities, there are things that cybercrime cases like online banking fraud, even the source code theft, credit card, debit card fraud, ATM fraud are becoming very common. Plus, businesses and individuals are using email, mobile phones, social networking platforms for business. Business and individuals are also increasing their uses by making use of such an online fund transfer, for doing any online transactions, for purchasing through Myntra, Flipkart, Amazon, and everything is happening online. So with an increasing, apart from this, everything, including an e-governance is being there. Now you can pay, you can file your income tax return online. You can make the GST payment online. So with an increase in the e-governance initiative, activities like filing income tax return, making the application to various government departments through online forms are now done in an electronic form. Digital signatures and e-contracts are fast replacement. So due to increase in all such activities, there are chances that right from credit card fraud, tax evasion, virus attack, phishing attack, email hijacking, denial of service attack, pornography, hacking, everything that we have seen so far is becoming very common. So even in conventional, there were non-cyber crime issues like murder, kidnapping, terrorist attack, uh, counterfeiting maybe the currency, civil matters. So all of them are now making a use of the internet, making use of the computers. So important evidence can be extracted for computers, mobile phones. So in such a scenario, there is a very much a great need for a cyber law which can deal with the technology in every aspect, so that a legal crime or a legal incidents can be followed. So here we end the module number 4, which was, we started with the concept of cyber line, and then we started with right from e-commerce to the Indian cyber law. I hope you have enjoyed the module number 4, and then we are going to start with module number 5. Any doubt you can raise, or just I hope you have understood. Any doubt you can raise, or else we'll start with module number 5. An announcement, an extra lecture is scheduled at 3:30 p.m. All of you are requested to kindly join that session, where we are going to have a very interesting sessions on module number 5, where we are going to speak on that. So what are we going to do in module number 5? I'll keep it as a suspense, not a suspense, so that you can think what we are going to learn, so that you'll have that thing that what are we going to understand and learn in that. But to give you a brief, we are going to speak on the cyber laws in India. So what are the different cyber laws we have? And we are going to have much more discussions probably on IT Act 2000 and 2008, right? So I think I do not see any doubt or so. Yeah, thank you, Gokul, for the update. So let us start again with module number 5 on the cyber laws. Let us proceed. So we are about to start with module number 5, which is the Indian IT Act. So the name of the module is Indian IT Act, and let me do a screen share, then we can start. Okay, so we are here to start with the cyber laws in India. Now, before I start with the module, I'll request everyone. Uh, I request everyone that we are going to see the cyber laws in India, but at the same time, if you all, along with me, can open the document which I would be sharing, so that you all can also see what are the different cyber laws we have. You should have the documents in front of you so that you can read it. So I'll just let you know about the same. So in this module, that is the Indian IT Act of module number 5, we are going to have a discussion on IT Act 2000 and IT Amendment Act of 2008. So this is what we are going to make an understanding of. So let us start with the scene. Okay, so let us start with Indian IT Act 2000. So Indian IT Act 2000, which is also known as ITA 2000 or the IT Act, it's an act of the Indian Parliament which is notified on 17th of October 2000, and its primary law in India is to deal with the cybercrime and electronic commerce. So Indian IT Act 2000 was there to provide, what you can say, in brief, if I say, it's again a primary law for dealing with the cybercrime and electronic commerce. Now, what does the definition says? ITAC 2000 is actually used to provide legal recognition for transactions that are carried out by means of EDI. Now, I hope you know what is an EDI. We have seen that in much more detail. So it is a legal recognition for transaction that is carried out by the means of electronic data interchange and all the other means of communication commonly referred as e-commerce. Now this also, you know what is an e-commerce, which may involve use of alternatives to a paper-based method of communication and information storage to facilitate the electronic filing of documents with government agencies. So in short, if I want to say, it is again an act where it deals with all the cybercrime and electronic commerce. Now for this IT Act 2000, from where are you going to refer? So I'll suggest that if you are referring IT Act 2000 and 2008, a very good source is being given on the bracket. If you can see here, you can download the document from here. This is the MEITY, that is Ministry of Information and Technology. If you can go there, it's an official government website. On that government website, they have entirely given an IT Act 2000. So you can make use of it, which is again a Bible, I can say, of the entire IT Act in detail. So if you are very much interested to understand the entire IT Act word by word, you can read IT Act the entire. You can entirely make use of an IT Act 2000. You can entirely read word by word from the given document. Or the otherwise, I've also uploaded on your Moodle account. You can just go to your Moodle, and on that Moodle account, I have uploaded the document for you, so that you can make the refer of it, so that you have an understanding about the IT Act 2000. Right? So I have included in the shorter terms in my slide as well. You can, in the exam, you can make use refer my slides, plus you can make use of the document which is shared, which is again a document which I have taken from, you can say, meity.gov.in, that is Ministry of the Information and Technology. From there also you can have a look, or else you can also read it from a Neena Godbole book. So choice is yours from wherever you want to read it. So if you want to read it in detail about each and every word about how the IT Act 2000 came into, right from its initiation to the naming, to all the different sections with all the different punishment that has been there, in detail you can make use on the website, which is government website, which gives the entire information, or else you can make use of Neena Godbole, which is given again in the simpler terms, or you can use my slide as well. Clear? Shall we proceed? Okay, Shubham. Yeah. So what we're going to do is, we have probably 3 minutes left. So what we'll be doing here is, it's 2:15. I think you might have a lecture at 2:30 as well. Okay, what we'll do is, we'll just discuss a brief introduction of an IT Act 2000. What are the different section it covers? The entire detail and entire coverage we are going to see again at 3:30, when we are going to meet and we are going to complete IT Act 2000 and 2008. And then we are going to see them in much more detail, right? So let us have an idea about it. So speaking to IT Act 2000, in IT Act 2000 you have various sections. You have section 43, which is used for data protection, section 66, which is there for hacking, section 67, which has been made for protection against unauthorized access, section 69, which is there for cyber terrorism, section 72, which deals with privacy and confidentiality. So there are different sections which we are going to look in the detail, and once we look at the detail, we are going to see what punishment or what is going to happen if somebody breaches that, somebody breaks that law. So anyone who does the crime of data protection, hacking, protection against unauthorized access, cyber terrorism, privacy and confidentiality are punished under section 43, 66, 67, 69 and 72 accordingly. So what if anybody does the breach of any one of the crime? If anybody does the crime on the internet, he is punishable under the act. So what is that act and what is the punishment that is going to get it? We are going to see at 3:30. You all are requested to join back at 3:30, where we are going to see in much more detail, and then we are going to see that. So when we speak about an IT Act 2000, IT Act 2000 has total of 13 chapters. So whenever you will read it, you will have total of 13 chapters, and the ninth chapter includes most of the law which is regarding the cybercrime. So we are interested much more in the ninth chapter, which includes most of the laws regarding the cybercrime. So all this probably we are going to see in detail in the second session, which is right at 3:30. So I hope you have enjoyed this session. You all can write your details, your UIN number and the roll number. We end the lecture here. You can join back at 3:30. Yeah, thank you, Sakib. Thank you so much. So if you want to refer, the entire ITEC 2000 document is already been uploaded in a Moodle account. You can have an access of the same. So apart from my slide, if you want to refer, you can make use the reference of the same. All of you are requested to kindly enter the details. We have less than a minute left. You can join back at 3:30.